Thanks for inviting me along today. So my name is Hanahoe, as I just mentioned. I'm the Data Protection Officer at Cambridge Assessment. I'm going to talk to you today about remote proctoring. Obviously, it's a very hot topic at the moment, and hopefully I will be able to give you some details about what remote proctoring is all about and the implications around data protection. Just going to introduce what I'm going to talk about in a moment, and talk about types of proctoring, data protection impact assessments and the necessity of those, the legal basis for the processing of the personal information involved, and the use of biometric data with AI proctoring. Before I get to that stage, I always put a disclaimer on my presentations. This isn't legal advice. Please don't treat this as gospel. I would always encourage you to talk to your data protection officer and or legal team within your organisation to make sure this what you hear here is prevalent to your areas. Another disclaimer that I think I probably should add is this is based on GDPR. This is the use of biometric data and the basis under the GDPR. Other jurisdictions obviously have different privacy legislation, and there might be different rules in different parts of the world. So please be aware of that when you're considering this, but this is obviously geared up towards GDPR. So the pandemic has really taught us that anything is really possible now with remote learning, and with the correct tools, we can really be quite effective working remotely. I do wonder what would have happened if the pandemic had happened a number of years ago, when we didn't have tools like Zoom and Teams, and internet connections weren't quite as stable. I think we'd be in a different situation. But now we are in a situation where we can work quite effectively away. We can learn away from centres and schools, and we can work away from offices. And one tool really that has allowed learning and assessment to continue is the use of remote proctoring. The technology is obviously in place for this, but there is the legality of the use of it has been brought into question on a number of occasions, and people do have quite strong feelings about remote proctoring and the use of remote proctoring and the invasion of it. There's been some quite high-profile stories in the press over the last year or so. The Amsterdam University case, where Amsterdam University decided to use remote proctoring, and the students took an action against that in June 2020. The courts in Amsterdam actually found in favour of the university that proctoring was a use, but it just shows that these things are in the press. And the Pakistan Airlines case, and you might not be aware of this one. This was quite a tragic airline crash where nearly 100 people were killed, and it transpired in the investigation that the pilot, nearly 260 Pakistan airline pilots actually had used proxies to sit exams for them, so weren't actually trained properly to fly. So it just really illustrates the need to make sure that exam integrity is maintained, either physically or remotely through the use of proctoring. Broadly speaking, to talk about proctoring, there are two types of proctoring that are used. There are human proctoring solutions and AI proctoring solutions, or automated proctoring. Both use webcams, both have a video aspect where the individual is being recorded. Both have implications, which I'll go through, and both will always require a data protection impact assessment. And I'll talk a bit more about DPIAs in a moment. They're sometimes called privacy assessments or privacy impact assessments, but really they're a due diligence process to ensure that the processing that you're intended is proportional and right to use. And they are really an essential piece of due diligence when you are considering any form of remote proctoring. Both types of proctorings have pros and cons. Human proctoring, I think one of the biggest things around human proctoring is the due diligence around the proctors. You are potentially exposing children to one-on-one conference with an adult, and obviously the safeguarding aspects of things there are key. Due diligence around the proctor providers, proctors themselves, who they use. A lot of proctor providers use third-party agents, temps or employment agencies to source their proctors. And I think a part of the process when it comes to human proctoring is ensuring that you're comfortable with the due diligence that the provider has done. Have the proctors been trained? Have they been DBS checked, as it is in the UK, or criminal checks to make sure they haven't got any convictions for things that could affect their integrity? What sort of audit provisions have you in the contract? Are you able to look at the training that proctors have done? Are you able to go in and audit to make sure that these things happen appropriately? With AI proctoring, obviously the different pros and cons. The use of biometric data is key within AI proctoring, and that has some quite significant implications when it comes to data protection, and which I'll talk to you about in a moment. Are using a tool which is some people will find intrusive, some people might not like at all. I think that's the difference. Some people will sooner a human be there and look at them. Some people might not like a human in the room and might prefer a computer. So a lot of it comes down to the individual's perception. But the AI proctoring and human proctoring both have pros and cons, as you see on the screen, and they both need to be considered when wondering which solution is best for you as an organisation. Now, I mentioned the data protection impact assessment a moment ago, and the DPA really is a very, very important tool when it comes to understanding the implications of processing data, not just for remote proctoring, but for all sorts of uses of data. And the Information Commissioner's Office in the UK and other data protection authorities around Europe have rules around DPAs and when they need to be used. And some forms of processing must have a DPA. And generally, anything that's automated using AI will fall into this category. So DPA really is essential. But even if you are using remote proctoring, human proctoring rather than AI proctoring, I would still suggest a data protection impact assessment is a very, very important document to have in place. It really should be there to show that you've thought about the implications of it, you've looked at the risks, you understand the risks, and you've got things in place to mitigate those risks as best as you possibly can. It should always be done in collaboration with your data protection officer, and they should be a living document. They really shouldn't be a standalone, once tick box exercise that you fill out the form and it sits on a shelf or on a computer somewhere. It needs to be a living document that's revisited throughout the development of whatever you're doing and into go live as well, to make sure that those risks you identified are still being mitigated in the correct fashion. With remote proctoring, I think with a data protection impact assessment, there are a few things that are essential to consider with this, and pretty much they're the same for all DPAs, but for remote proctoring, they should really be highlighted. Establishing what legal basis you're processing the information under is key, and I'll talk about the legal basis in a moment, but it's very important. Legal basis is appropriate for the processing. You can't just pick all of them and hope for the best. You have to be able to establish which one you're processing the data under. Retention is another key issue when it comes to remote proctoring. Obviously, where videos will be kept for a period of time. If there's no suspected malpractice within the assessment, it can be deleted relatively quickly. But if there is malpractice suspected, then obviously that will have to be kept for longer. Having a clear retention policy and having that information available to the test takers is very important for your privacy notices. And transparency, being able to show that the test takers how you're going to process their data, what you're using it for, etc., is key, and that should all be done through terms and conditions and privacy notice, and drafted in a child-friendly way as well. If your test takers are under 18 or potentially under 16, depending on which jurisdiction. In the UK, we just the Children's Code is about to come out in September, which stipulates that if you're dealing with children under 18, then you have to make sure that things like privacy notice and terms and conditions are drafted in a way that are user-friendly for them and they can understand them. So transparency is key with all of these things. Now, with your legal basis for processing, you have 4 really main areas which you can come under. And I'm talking about the legal basis for the proctoring as a whole. I'll talk about the legal basis when it comes to biometric data and AI proctoring in a moment. But for processing data for remote proctoring, you really have 4 main areas that you can go for: consent, contract, public interest, or legitimate interest. And really, this is where you'll need to decide in your DPIA alongside your data protection officer and legal team which is appropriate for your organisation, because some will not be appropriate for some organisations when others will. So consent under the GDPR, it changed quite dramatically from the old legislation we had in place. Has to be freely given and can be withdrawn at any stage now. So with consent, you can't make, so with proctoring, you can't make consent a condition of entry. So if there's no alternative to remote proctoring, then consent probably won't be the right legal basis for you. Because if you're saying you have to consent to the proctoring in order to take the test, then that can't be considered freely given, can it? And there's also the question of whether people will be consent to be caught cheating, because really that's what proctoring is all about, really, to ascertain if malpractice is taking place. So consent really for the processing of personal data for proctoring probably isn't your best bet. For contract, you could be argued that to fulfil the contract with the individual, the test taker, that it's necessary to remote proctor the exam. It's the option. Again, this might be difficult to say that it's a condition of that contract, when someone could argue that they could take the test in a centre. I would say that's, again, probably a weaker basis for processing. Public interest. Now, this will only really be available if you're a public authority, as defined by the various legislation in your various pieces of legislation in your country. In the UK, universities, for example, are considered public authorities, as are schools. So potentially this could be used, but it really has to be derived from law. So in the UK, the Apprenticeship Skills, Children's and Learning Act imparts duties on the Department for Education, which they, through Ofqual, put onto exam boards. So public interest could be used for public exam boards. And then the public interest really there would be maintaining the integrity of examination. I think it's obviously a very clear point that we must maintain academic integrity and assessment integrity, and it's in the clear public interest to do so. So as a public authority, public interest could be one to rely on. But for private organisations, I think legitimate interest will be the go-to legal basis for processing information for remote proctoring. And the legitimate interest there is in, again, maintaining the academic integrity of assessments, both for the organisation providing the assessment and members of the public as well, and other organisations who will rely on these examinations for employment, for example. We need to be able to show that the individual has sat the test appropriately and has not cheated and got the mark fairly. So there's a clear legitimate interest for the exam board or the test sitter, the organisation setting the test. There's clear and legitimate interest for things like universities, employers, border agencies, etc. Whenever you do use a legitimate interest as your legal basis, you are required to perform a legitimate interest assessment. I'm not going to go into too much detail of those here, but there's templates certainly on the ICO websites, and I'll be very surprised if there isn't templates for legitimate interest assessments on other data protection authorities' websites across Europe. And this is, again, a due diligence process whereby you show what the legitimate interest is in the processing and how it's justified, how it justifies the process. And I think if you're relying on legitimate interest as for processing in this, that should sit alongside the DPIA really and form part of the due diligence documentation that you have in place. Now that's for processing of normal personal data, your name, email address, IP address, etc. But for AI proctoring, you also have the issue of you'll be processing biometric data for identity purposes. Now, when you process biometric data for identity purposes under the GDPR, this is considered special category personal information. And special category personal information has a higher level of care or burden of care imparted on it, which means that you really have to be very careful how you're processing that information and be confident of your legal basis. Now, for some public authorities, you might be able to rely on public interest, which I'll come to in a minute, but that's only really available for those public authorities. For other organisations, for private organisations, really the only way you can process biometric data will be via explicit consent. Now, this could cause issues when it comes to AI proctoring, because really, if, as I mentioned earlier, if consent is a condition of entering the exam, then it can't be freely given. There's quite a big disparity, obviously, between the two parties, the test taker and the organisation. So they really can't be considered freely given consent. If you're saying to sit this exam, you have to be AI proctored, and to be AI proctored, you have to give us your consent. Any data protection authority is going to look quite poorly upon that, because you really are making condition a condition of sitting, making consent a condition of sitting the exam. To get around this, to negate this problem, I think the easiest way is have alternatives to AI proctoring. I think if you are looking at any form of AI proctoring solution, then you must have some alternative to the test taker if they don't want to consent. So this could be a human proctored exam, for example. So you could offer, if someone says, I'm dead against my biometric data being processed for this purpose, you could offer them a human proctored exam, or potentially an exam in a test centre. If there's a test centre available to them, then you can say, okay, fair enough, you don't have to be AI proctors, you can go to the test centre and be invigilated as a normal exam. Excuse me. Unfortunately, during lockdown, this could be difficult. And I think we've, where I am at Cambridge Assessment, we ran into this issue during the lockdown, where if we're trying to use AI proctoring, the alternative will be a test centre, but during lockdown, people aren't allowed to travel, it's illegal to travel, potentially that could be a big issue. And also I feel if there is a long distance, if the individual has to travel many miles to reach a test centre, then potentially this could be a block on them being able to take the test, so forcing them to be AI'd again, so the consent can't be freely given. Really, the simplest option is if you're running an AI proctored solution, have a human proctored solution along the side of it. And I did mention a minute ago that there is a public interest for public authorities. Potentially this could be for use. So under Article 9G of the GDPR, it allows for processing special category where there's substantial public interest. And with regards to proctoring, I think that substantial public interest will be protecting the public against dishonesty. There has to be a basis in law for this, and I think fraudulent activity or dishonesty in exams could well be argued there, especially if the exams are high stakes exam. For example, medical exams. There's been cases in the UK where individuals have cheated on English language courses, then achieved jobs as doctors, and have actually put people's lives at risk because they didn't have the level of English necessary to treat patients appropriately. And that Pakistani Airlines case that I mentioned a moment ago, that's a very clear public interest in maintaining that academic integrity and that assessment integrity, whereby someone who cheats on an exam could potentially put many, many lives at risk. So I think there is a clear public interest there in maintaining integrity, but as I mentioned, that's probably only available to public authorities. If you're a private organisation, I think consent will probably be your go-to legal basis for processing. Now I've rattled through that rather quickly. I see I'm a bit ahead of time, so if you have got time for questions, if anyone would like to ask some questions, or if anyone would like me to go over some of the points I've raised, which I rushed through slightly. I'm sorry if I did rush through them. If you'd like me to go over any of the points mentioned, or if anyone has any questions, please feel free to ask away. I'm not sure how the question will work on this platform. Are they? I think individuals will come up to the stage to ask, or someone can read them out. Unless there isn't any questions, then you'll get a bit of time back.
No, thank you very much indeed for that presentation, Ian. It was actually very informative, and of course, you realise it's a very, very important part of the work we do and of the changes that are taking place at such a fast rate in our professional lives. I'm just wondering if there are any questions. I'm looking at comments, certainly, on the participant chat channel. I'm just want to see if there are any more questions here. Yes, can you explain a bit more about legitimate interests?
Certainly.
Yes, please. Thank you.
So just go back to the slide there. So legitimate interest is one of the legal bases for processing personal data, established by the GDPR. It's quite often it's used when another basis isn't available, where you haven't got a contract, or you can't argue that the processing is necessary for that contract. So legitimate interest, you really have to be very clear on that legitimate interest. You have to be very clear that there is a real legitimate interest in the processing. And I think for proctoring, that legitimate interest would be maintaining that assessment integrity, both for the assessor themselves, the exams board or the exams organisation, but equally anyone who's going to rely on that qualification. So the individual themselves, the test taker, they have a legitimate interest to a certain degree that the integrity of their exam is maintained. You know, it's never brought into question that it could have been cheated on. But more importantly, I feel it's the legitimate interest of, say the assessment's been used for entry to a university, or to say that someone's got a level of language for entry into a country, or for medical school, or something equally high stakes, the Pakistani airline industry, that example, I'll come back to that. I think there's a very clear legitimate interest of organisations that will rely on that assessment as a benchmark of that individual's ability and learning. So being able to remote proctor a test is a very clear way of making sure people don't cheat. So there's a legitimate reason to do so. If you just let people sit the exam without any form of invigilation or proctoring, and they were able to pause and carry on as much as they want, or read, or have someone else sit the test for them, then clearly it's not going to be in the interests of the organisation or anyone else who relies on that test. Another point, actually, someone brought up when we were discussing this is particularly the legitimate interest of other individuals as well. If someone cheats an exam and gets entry into a university where there's a finite number of space, by definition, they're taking that place away from someone who potentially hasn't cheated, or probably hasn't cheated, because it's obviously not the common practice. So I think there's a legitimate interest of other individuals as well. Where you're a public authority, then you rely on the public interest, which is very similar, but relied on for public authorities because they have that public duty, and there's a clear public interest. I hope that clears the legitimate interest up somewhat, but it's quite a complicated area, and I think the last line on that slide there about a legitimate interest assessment is very important. Whenever you rely on legitimate interest for any form of processing, then a legitimate interest assessment is a very important document to have.
Okay, so thank you for that. And we have another question, in fact, two questions on safeguarding young learners in the process. Yeah, I'd like to talk about that.
Really, that's not my area of expertise, I will say, but they do go hand in hand somewhat. Now, when you're using AI proctoring, there isn't necessarily that safeguarding issue. Or when you're using record and review proctoring, that there isn't necessarily that safeguarding issue. But when you have a one-on-one situation where you have a minor online on a webcam with an adult, then under many jurisdictions there are requirements to safeguard that child. That can be done by chaperoning. But chaperoning obviously has its own issues as well, because there could be a parent whispering answers to an individual, to a child, so there is implications there. But that chaperoning is certainly one way of stopping that. Remote proctoring a large group, so a group within a room on a computer, on different computers, being monitored by a teacher. That's another way of maintaining that safeguarding. But I think one of the most important things when it comes to safeguarding is making sure that you're confident in your provider's due diligence that they've conducted on their proctors. A lot of proctors providers, obviously, especially during lockdown when the demand for this shot through the roof, they didn't have the staff in place to really feed the demand. So they had to get agents in and a remote staff to be able to meet the demand. And I think it's very important to make sure that as it's your test that's been proctored by a provider, that you are confident that they are using the right people. So I think criminal checks are an essential part of that, making sure that all of the remote proctors are criminally checked, make sure there's nothing there untoward, making sure that they're trained appropriately, making sure that they're checked and audited on an ongoing basis. And I think there's certainly no harm. You wouldn't be doing your due diligence properly if you didn't really stipulate within your contract with the provider that this was an essential part of it. I would expect in any contract around proctoring to have very stringent provisions around the checks that proctor providers need to conduct on their proctors, and also the ability within the contract for you as an organisation to audit the proctor provider, to go in and ask for them to show you good evidence that what they're doing to check their proctors is up to scratch. So I think the safeguarding issue is not my area of expertise, as I mentioned. and I would certainly discuss that with the safeguarding teams within your organisation. But I would expect it to form part of the DPIA as well, that you've considered this, and the checks and the due diligence is done both by the providers and the proctors themselves, and those audit provisions within the contract, I think, are key.
Okay, very interesting. Another request to show the slide relating to contract again, please.
Which way? This way. Yeah, contracts. So as I mentioned, I think contracts is a possibility as a legal basis. It wouldn't be my first choice, if I'm perfectly honest, because I think it would be quite difficult to say that one of the conditions of that contract is that the assessment's remote proctored. I think the argument could be that could be termed an unfair term within a contract, and the test should be checked in a different way. So I'm not sure contracts would generally work, but people have discussed it as a potential one, but it wouldn't be my choice. I would always plumb for legitimate interest or public interest as a legal basis.
Another of our colleagues has suggested that perhaps we shouldn't really consider stakes at all, and have the same approach to all qualifications.
Yeah, that's something that's been brought up. I think I put it at the first slide. Is remote proctoring actually necessary? And I think a lot of that depends on the nature of the assessment. Which way are we going? The nature of the assessment itself. I would suggest that if the assessment is low stakes, there isn't a degree of importance to it that means it could be leading on to higher or further education or to employment or entry into a country, then potentially there's no need to remote proctor. But I think if there is if there is that high stakes nature to the assessment, I think by rights as assessment organisations we should be protecting the integrity of it. Okay. I think the difference people feel is that we're used to sitting exams in big halls where invigilators walk up and down and check we're not cheating. This is designed to do the same thing, but it's a far more intrusive way of doing it. That's the problem, and people find that intrusion difficult to live with sometimes.
And a comment here, I think it's been repeated, from Beate Zeidler, who says it's perhaps important to stress that the reason for data processing is not important. It is the fact that you do it at all, really, I suppose.
Yeah, exactly.
You disagree with that, yeah.
I certainly agree. And I think I'll always come back to these DPIAs. I think the DPIA is such an important document to have, to show that you've considered these matters appropriately. So a DPIA should always be conducted with any of these.
So I think we've had quite a number of comments and quite a few questions, because it's obviously an issue that's very close to us all at the moment, and should always be, no doubt. Thank you so much for that really interesting presentation, very clear, and for answering so many questions. And again, I think it's an indication of how useful people found your presentation, that it elicited so many comments and so many questions.
Thank you very much.
Thank you so much indeed, Ian. Thank you.
Just a brief plug as well. I'm also doing one tomorrow on GDPR and automatic marking, which automatic decision making has some quite stringent implications as well. So I've got a presentation on that as well. If you would like to know more about that, as a shameless plug, I must admit, but please come along if you're interested. No, there are some similar plugs in the chat as well. So from other sources as well. So that's what we're all about. The more knowledge from as many sources as possible, the better for us all. So thank you so much indeed. My pleasure. My pleasure.
Thank you now, Ian, for that. It was wonderful. Thank you.
Thanks a lot.
Bye.